Good afternoon to you. Today we will continue with Constitution. We will take it up parliamentary privileges. That is the privileges enjoyed by the members of parliament individually and both the houses of parliament and also the committees which are functioning under Lok Sabha and Rajya Sabha. All put together we call this as parliamentary privileges. You know there are three sets of people. One is citizens of India and another is government servants. And the third is members of parliament. All the citizens of India are entitled to fundamental rights. As we have already seen, some fundamental rights are exclusively for citizens and some fundamental rights are both citizen and non-citizens. But if you take government servants, certain fundamental rights have been restricted in their application in respect of government servants. But the members of parliament rights are abundant. They enjoy full freedom of speech and expression, unbridled freedom of speech and expression, except of course subject to the provisions of the constitution and subject to the rules of procedure of the house. So their freedom can be restricted only on two grounds. One is constitutional restrictions and the other is with the restrictions which are laid down in the rules of procedure made by Lok Sabha and Rajya Sabha. Only these two restrictions apply to members of parliament. Subject to these restrictions, members of parliament are entitled to abundant freedom. Now, this looks very, odd. Why? Because the preamble of our constitution declares the commitment of the country to secure to all its citizens justice, liberty and equality. This is already given in the preamble. The fundamental right, that is Article 14, mandates the state not to deny to any person equality before law or equal protection of law. Similarly, Article 15 prohibits the state to discriminate among citizens on the ground of religion, race, caste, sex or place of birth. Article 18 abolishes all titles. The title to nobility as a privileged class does not exist now. The zamindaris and jagirdaris have been dispensed with. So also the rajas and maharajas. The privileges and other pension, financial benefits provided to the princes have been abolished with the abolition of privy purses. The constitution has the sole aim to establish an egalitarian society which is casteless, which is classless, which is socialistic and also secular, assuring equality to all citizens, howsoever they are high, howsoever they are low. Right from the Prime Minister to the Chaprasi, all people are entitled for equality before law and equal protection of law. Right from the Prime Minister to the Chaprasi, all are entitled. Any law made even indirectly making any discrimination cannot stand before the scrutiny of the judiciary. Having said this, viewed in this background, remember, the immunities and privileges extended to the members of parliament under Article 105 of the Constitution, for any person, it may look contradictory. Definitely, it may look contradictory. When our commitment is to build a equalitarian society, how can you justify some special privileges given to some group of people, say members of parliament? This is a normal question which arises in the minds of every individual in our country. Now, the reasons for the special privileges which are available for the members of parliament is not very far to seek. If we should appreciate that the members of parliament are our representatives. Each member of parliament, Lok Sabha, represents at least minimum 10 lakh people of our country. They are elected by us. So long you believe in democratic tradition, so long you believe in parliamentary democracy, it is your bounden duty to respect the members of parliament. They convey the views of the people by virtue of their position. Remember, by virtue of their position, they have to discharge number of duties and responsibilities to fulfill their obligations. Both the houses of parliament have to perform the task on behalf of the nation. Society is nothing but a hub of contradictory interests. A number of times a member of parliament have to say or to do in the house which are many times unpalatable to some group of people in the country, especially the rich and the powerful. Many times people may not like the way the member of parliament exercises his vote. In due discharge of their duties, there may be occasions when the member has to expose scandals. You might have seen so many scandals have been exposed by the members of parliament while they speak in the house. Exposed the fraud, they have exposed the scandals, they have exposed other kinds of corruption, they have exposed other kind of misconduct prevalent in the society. Many people may not like such exposure coming before the public domain. That is natural. In this process, the members of parliament expose themselves to the threat, even physical attack, and even legal action on the charges of defamation, and even their own life for what they say or the manner in which they exercise the vote in the house. In such a situation, the members of parliament may not be able to act without fear or without favor in the parliament. Therefore, in the larger interest of the people of the country, members of parliament should be duly protected to express themselves in a free and forthright manner and discharge their duties without fear or favor and conscientiously. It is necessary to insulate them in any consequences of what they may say or what they may do or in what manner they exercise their vote either in the parliament or in the committees of the parliament. In these circumstances, the members have been given certain special rights with a view to protect their functional freedom. Underline functional freedom. Such of these special rights are called parliamentary privileges. These privileges provide congenial circumstances to the members of parliament for the effective, efficient functioning of their functioning in the legislature in protecting the larger interests of the people of the country. In fact, the term parliamentary privileges itself, I do, and personally I feel it is not correct because Union Parliament consists of President, Lok Sabha, and Rajya Sabha. Whereas the parliamentary privileges which are included in Article 105 is relating to only Lok Sabha, Rajya Sabha, members of Lok Sabha, members of Rajya Sabha, and the members of the committee functioning under both Lok Sabha and Rajya Sabha. President is not included under Article 105 of the Constitution because for President of India, the special privileges available to him is elaborately given in Article 361. So, the parliamentary privileges covers only Rajya Sabha, Lok Sabha, the members of Lok Sabha and Rajya Sabha, and the committees which are functioning under both Lok Sabha and Rajya Sabha. So, Article 105 confine only this. Now, the privileges of the members of the parliament do not imply that they have been placed in a higher footing than that of an ordinary citizen. The basic principle is that all citizens, including the members of parliament, should be treated equally before the law, including members of parliament. All are equal in the eyes of law. Howsoever they are high, the law is higher than them. Howsoever they are tall, the law is taller than them. Both the citizens and the members of parliament enjoy same rights and obligations outside the parliament. However, the privileges available to the members only when they function as representatives of the people. So remember, the privileges available to the members only when they function as representatives of the people inside the parliament and discharge their parliamentary responsibilities. These privileges do not exempt the members from their normal obligation to the society, which may apply to them as much as they apply to normal citizens. To cite an example, a member does not enjoy any exemption from the operation of any ordinary law of the land. And as you know, the Supreme Court has held that in a case, a member of parliament does not enjoy any special privilege with regard to censoring of mail or tapping of telephone authorized by law, which is equally applicable to all citizens. With this background, we will see the constitutional provisions which provide parliamentary privileges to members of parliament, to both the houses of parliament, and also the committees functioning under them. Article 105 says that, subject to the provisions of the Constitution and the rules regarding the procedure of both the houses of parliament, there shall be complete freedom of speech. Remember, complete freedom of speech in parliament. This article gives absolute immunity from the court. Absolute immunity from the court for anything said within the four walls of the house during the proceedings of the house or during the proceedings of their committees. Remember, what is protected under Article 105 is only the speech within the house. Outside the house, every member is as good as any other citizen. So, if a member repeats or publishes a defamatory speech which has been made by him within the house, if he repeats it outside the parliament, he does so on his own responsibility and on his own risk, and he will be liable for prosecution under section 500 of Indian Penal Code if the speech is defamatory. Most important point you should remember. The article clearly says, subject to the provisions of the Constitution and to the rules of procedure of the House. So, subject to these two, what does it mean? One of such a constitutional restriction is on the freedom of speech and expression in Parliament is given in Article 121 of the Constitution. Article 101 prohibits any discussion in Parliament with regard to the conduct of a judge of Supreme Court or High Court in discharge their duties except upon a motion for their removal. Similarly, freedom of speech and expression is restricted in the rules of procedure of the House made under Article 203 of the Constitution. Rules 349 to 356 of Lok Sabha procedure restricts the use of unparliamentary language in the House. So also unparliamentary conduct of the member. Similarly, no member of parliament is liable to any proceedings in any court in respect of anything said or any vote given by him in parliament or in any committee thereof. So also no person shall be liable in respect of any publication by or under the authority of either House of Parliament of any report, paper, vote or proceedings. This protection is not available to any publication made by a private person without the authority of the House. So, this is the powers given, and this is only one part. There are many number of provisions. I will restrict this only up to this. We will deal with it further in the next class. Thank you.